Hello, and welcome to the first chapter of my course on intellectual property and trademarks. Whether you are starting a new business or growing your brand, or simply curious about how to protect what makes your business unique, you've come to the right place. My name is Omer, and I've spent a decade helping businesses safeguard their identity and avoid costly legal pitfalls. In this course, I'm excited to share my experience and insights with you so you can confidently navigate the world of intellectual property and brand protection. By the end of this course, you will understand the key steps to securing your business's most valuable assets. Have you ever thought about protecting your business name or business logo? Well, you'll learn how to do that in this chapter. So let's just begin. Think about the most iconic brands you know. I can think of three on the top of my head: Nike, Apple, and Guinness. What do these brands have in common? They are not just protecting their products, but by their intellectual property, their names, logos, and design. And all of them are part of that identity. And that's what makes them stand out in the market as well. So the key points to take away is protecting your brand identity helps build customer loyalty and prevents competitors from copying your success. What is intellectual property? Intellectual property, or IP, refers to the creation of the mind. These can include inventions, product designs, artistic work, and most importantly for businesses, trademarks. Protecting these assets mean protecting what makes your brand unique. There are about 12 to 14 main types of intellectual properties, offering unique protection for different aspects of your business. Consider intellectual property as property. It is property. It can be bought, it can be sold, it can be licensed. So get into, if we do a deep dive into the different types of intellectual property, and for example, what you can see through this, which type of IP do you think would be the most important for your business? So, number one is patents. A patent is a legal right that allows the owner to stop others from using an invention. For an invention to be patentable, it must meet certain criteria. For example, it needs to be novel, non-obvious, and have industrial applicabilities. Importantly, a patent must go through an examination process and be granted by the relevant authorities, not just filed, for it to be enforceable, for instance. And once it's granted, the patent provides exclusive rights for up to 20 years. However, be cautious about publicly disclosing your inventions before filing a patent, as this could very well prevent it from being granted. There are two main types of patents: utility patents, which protect new inventions or processes, and design patents, which protects the appearance or the design of a product. Each type of each type serves a different purpose, but both offer strong protection for this. One famous patent case involved the smartphone wars, where Apple and Samsung fought over design and utility patent related to smartphone features. These cases does illustrate how patents can protect both the functionality and the aesthetic in highly competitive industries. Number two, we have trademarks. Trademarks are signs, like words and logos, that distinguish the goods and services of one business from another business. So from business A to business B. Trademark relates to branding. They guarantee the origin and identify a product. A registered trademark provides strong protection and theoretically can last indefinitely, subject to renewals every 10 years. A famous trademark dispute between Apple Incorporation and Apple Corps, the Beatle record label, where both companies fought over the use of Apple name in the music industry. Despite a settlement agreement in the 1980s, another dispute arose when Apple Inc. entered the music market with iTunes. Trademark conflict like these highlights the importance of clear definitions and boundaries when it comes to brand names, right? Number three, we have design rights. Design rights protects the overall shape and the visual appearance of a product and can cover both three-dimensional products and two-dimensional designs. Registration or a registered trademark design lasts up to 25 years in United Kingdom, while an unregistered trademark offers 15 years of protection. Design rights may and do differ by countries. For instance, US design patents last for 15 years, and in the European Union, unregistered designs are protected only for 3 years. This means businesses operating internationally must understand the varied protection and laws across different regions. Number four, copyrights. Copyrights protect original creativity and creative works like literature, music, and softwares. Copyrights exist automatically upon creation in any tangible form, like an artwork or a book. In addition to the economic rights, copyright also grants moral rights, which protects the creator's reputation. Moral rights ensures the author is attributed and that their work is not used in any way that distorts or misrepresents it. For example, if a painter work is edited and sold without permission, the painter has the right to object. Number five, we have trade secrets. Trade secrets protect confidential business information or processes that gives a competitive advantage, such as formula, design, or practices, even practices. The secret formula for Coca-Cola is a famous example. Maintaining a trade secret requires a strategic approach. Companies often use non-disclosure agreements to protect confidential information shared with employees or external partners. Other strategies include limiting access to sensitive information and using encryption for digital data. Without these measures, a company could lose its competitive advantage. Number six, we have something called geographical indications, GIs. Geographical indications protect the name or signs used on a product that correspond to a specific location, like champagne, like Scotch whiskey, like Manuka honey, and I think basmati rice would come under that as well. GIs not only protect uh, product quality, but also help preserve cultural heritage. For centuries, the term champagne has been represented has represented a specific region in France known for its sparkling wines. Similarly, Manuka honey is from New Zealand. It represents a certain quality, a certain certification behind it. So geographical indications are very important to identify the origin of the product as well. In number 7, we have something called plant breeder rights. What it protects is new plant varieties that are distinct, uniform, and stable. These rights gives breeders the exclusive control over propagation of their plant variety. For example, rights over new flower varieties or genetically modified crops. In number 8, we have domain names, a unique website address that can also overlap with trademarks if the name corresponds to the registered brand. So, for example, Amazon.com, protecting both domain and the brand name, right? Then, number 9, we have industrial designs. The external appearance or visual design of an object that is both novel and original, including 3D shapes or 2D patterns applied to a product. So, for example, a shape of a car, an ornamental design for an item of clothing, or an electronic device like smartphones. Number 10, semiconductors topography rights. What it protects is the layout design of semiconductors, integrated circuits, for example, microchips, the specific 3D layouts of a microchip used in electronics that can be protected as well. Then we move on to some things that are specialized intellectual property areas. For example, performer's right protects the right of a performer, such as actor, musician, or dancers in their performances. We have moral rights, so non-economic rights associated with copyrights, giving creditors the right to protect the integrity of their work and be recognized as a creator. We have spoken about this in under copyrights. Then we have something called database rights, which protects the database and collection of data, giving the creditors, the creator, control over how the database is used, right? So if we take a real life example of Guinness, one of the world's most famous beer brands, Guinness name and its heart symbol and even its packaging are all protected by trademarks. One of the reasons Guinness remains a leader in the market is its ability to enforce its trademark. For example, in 2005, Guinness fought a legal battle against an imitation beer, trying to copy its iconic packaging. Trademark laws helped Guinness protect its brand identity and its market share, right? So today, we look at different types of intellectual property and how they offer different protection to different aspects of the businesses. In the next video, we will learn about trademarks. What is a trademark? What isn't a trademark? We'll dive deep into the worlds of trademarks. Until then, I hope you have a lovely week. I'll see you in the next video. Take care. Have a lovely day and a week and a month and a year. Adios. Bye.